Hi, I'm Don Main from On-Site Mediation and Arbitration. Today I'd like to talk to you about choices that have to be made when a grievance doesn't settle during the grievance procedure. I've been there and have had to make choices. Do you go to mediation? Do you go to arbitration? Do you go to Med-Arb, or do you choose Arb-Med, whatever that is? So what's the right process for your dispute and the ongoing relationship? So I'd like to talk about these four choices, and I've chosen four colors, one for each of these choices. Mediation involves an independent, experienced mediator facilitating a dialogue between the parties. So the goal of mediation is to achieve common understandings, facts, issues, processes, and compromises, maybe settlement. The process the mediator uses is often a modified SWOT analysis, the strengths, the weaknesses, opportunities, and threats. So they start with a joint session and the parties give context to the grievance and the issues, and then they separate the parties into separate rooms and the mediator goes back and forth trying to talk to the parties about different options and how they can come together on the issues. You do want to choose mediation where you feel that more dialogue is needed between the parties, or maybe dialogue within your own team on the issue. You choose mediation when agreement is needed on sub-issues, process, disclosure, or where there's a backlog of issues, many grievances that have to be whittled down because the parties couldn't afford to have them all go to arbitration, or couldn't afford not to resolve them. You choose mediation when the parties have a positive relationship that can be further cultivated through dialogue. So the expected outcomes of mediation is further improved dialogue between the parties. You can expect progress on resolution of the issues in dispute, even if there's no final settlement reached on a particular issue. You can expect an awareness to be given to both parties of the probable outcome at arbitration. They'll have discussed it with the mediator. The valuable education for team members attending mediation, and that education will assist them in avoiding a repeat dispute. The familiarity with mediation methods will help the parties to talk through difficult issues in the future. So a lot of positive outcomes from mediation. Arbitration involves submitting your dispute to an independent, experienced arbitrator for a final binding decision. And the goal is to achieve a final resolution of the dispute. The buck stops here. So this involves a hearing, very formal process such as subpoena of witnesses and documents, order of proceeding, exclusion of witnesses, examination and cross-examination, burden of proof, formal argument with case law, and statutory and contractual rules of interpretation. The hearing speed is sometimes painstakingly slow because everything is taken down in longhand. You choose arbitration when there's fixed positions between the parties or within one party's team that requires a ruling. You choose arbitration when the parties need clarity on the interpretation or application of a contract or statutory provision. You choose arbitration when there's discrete, defined issues that can be addressed in this process. And you choose arbitrations if the parties are comfortable with the arbitration process. If that's the way they want their dispute resolved, then that's the way they should go. Arbitration, the expected outcome is that the award will be final and binding and will determine the issue in dispute. Normally, one party's argument will be successful, which means the other party's argument is unsuccessful. Contract or statutory language will receive clear interpretation for future application. and the parties' relationship is able to move on to other issues. They can put this dispute behind them because it has been decided. The third option is Med-Arb. It's a little bit of both. Med-Arb involves an independent, experienced mediator arbitrator, somebody who's capable of doing both, who will attempt to mediate a settlement, failing which that person will deliver a final binding award. So the goal is to achieve finality, if not by settlement, then by award. So the approach starts with an informal session where the mediator is familiarized with the issues and suggests resolutions that might not be available at our arbitration. So that's how it starts. You choose Med-Arb when there are settlement opportunities that would normally be beyond the jurisdiction of an arbitrator. You choose Med-Arb when there's need to influence individuals on a team who might stand in the way of a settlement. You choose Med-Arb if there's need for an award to document a settlement and one party is reluctant to sign. So this is where they come to a settlement, but the employer or the union says, but I don't want my name on that, so why don't you award that? And the arbitrator does that. You choose Med-Arb if the parties are ready to submit the dispute to last chance settlement discussions, otherwise final binding disposition. It's a final choice for that particular grievance. So the expected outcomes of Med-Arb is that the parties have an opportunity to present their entire side of the story in an informal atmosphere. Individuals taking unreasonable positions will be discouraged by the mediator during the mediation process. The mediator arbitrator will have a better contextual background in which to fashion the settlement proposals or even the award. And the final outcome will likely be predicted early in the mediation session, making arbitration unnecessary. In Med-Arb, it's unlikely that you need to go to arbitration because everybody almost knows the result before the arbitration case starts. The last one, Arb-Med, a reversal of terms, it's a recent trend in arbitration where certain arbitrators, not all of them, but certain arbitrators are known to impose mediation during the arbitration process for some or all of the issues. You think you're going to an arbitration and the arbitrator turns it into a mediation. The goal is to force a settlement and dispense with a lengthy arbitration process. The approach starts with arbitration. After the opening statements, the arbitrator focuses in on the issues in dispute and presses the party for an abbreviated process or push for a settlement. So an example would be, and these are examples of, go in with opening statement and the arbitrator then says, well, I don't want to hear from your witnesses. Tell me what your witnesses were going to say, and we'll only hear if there's a dispute from the other side as to what they were going to say. So you might have 10 witnesses there, and you have to list all the stuff they're going to say, and the arbitrator takes it down, and then he turns to the other side and says, all right, is there any dispute with any of that evidence? And you narrow the evidence down, and once the evidence is narrowed down from both sides, the arbitrator says, now I'll hear your final argument. So you're gone before lunchtime. Sometimes you feel like your whole case hasn't been heard because your witnesses haven't had a chance to tell their story. You choose Arb-Med when there's settlement opportunities that would normally be beyond the jurisdiction of an arbitrator. You choose it by choosing the right arbitrator. You choose Arb-Med when there needs to be influence put on individuals who are standing in the way of a settlement. You choose it if the case would potentially be a very lengthy case and be too expensive for the parties. You choose it if the parties can agree to an arbitrator who's inclined to mediate that dispute. Arb-Med, the expected outcomes, is the parties will be restricted to the essential issues necessary to decide the case. Unreasonable positions will be discouraged. The arbitrator-mediator will make efforts to resolve any sub-issues and the entire dispute very quickly. And any party who's not prepared for this process can be caught by surprise and may feel they didn't have their day in court. So the summary is, which one do you choose? Well, select a process that is comfortable to the parties and the relationship. Well, that's easy. But you also have to select a process that's likely to resolve the dispute in an efficient and economical fashion. You want to select a process that doesn't damage the ongoing labor relations, and one that can be built upon for future dispute resolution. I hope this discussion helps you in making your choices for your grievances that did not settle during the grievance procedure. This is Don Main. If you need to follow up with questions, you can email me at donmain@gmail.com. On-site mediation and arbitration. Thanks.